Hello and welcome to HR Options webinar series. My name is Tim Baker, Business Development and HR Representative with HR Options, and it's my pleasure to be your moderator for today's session, where we will discuss Canadian immigration. Our speakers are experts in both human resources and immigration law. Before I introduce you to our speakers today, I'd like to do a quick review of what you can expect today. We promise to make your experience both informative and interactive, with many great features with our new platform for webinars. You will notice at the bottom there is a widget bar on your screen, and that will allow you to open up additional windows for more functionality during this session, including social media widgets in case you would like to engage your own networks. There are also several windows open on your console, including the Q&A window, and you're welcome to submit questions throughout the session, and we will respond to them at the end. For those of you that are looking for a slide deck and other resources, please visit the resources window on the middle right of your screen. This webinar has been approved for 1 recertification credit hour toward the PHR, SPHR, and GPHR recertification through the HR Certification Institute. Lastly, there is a red widget at the bottom of your screen for an evaluation that I'll be asking you to complete at the end of the session, prior to the end of the session, actually. If you have to leave early, please take a moment to complete the survey before you close out. We appreciate your feedback. HR Options offers the webinar series because we believe in value-added services. We would like you to become familiar with HR Options and keep us in mind for supporting your organization when you have workers you want to use but not employ directly. We offer payrolling and outsourced employment services throughout the U.S. and Canada, as well as HR consulting support. So please give us a call to discuss your organization's needs. And now on to our featured topic, Canadian Immigration 101. We have 2 subject matter experts with us today. Stacey Class, Certified Human Resources Professional, who's a senior consultant with HR Options. Stacey has been working with HR Options for over 9 years as a consultant, providing HR support for clients throughout various industries. And I know Stacey very well as we work side by side each day. Welcome, Stacey. Next, we have Melody Hughes. Melody is a senior associate lawyer with BOMS's Law Group, Corporate Immigration Department, where she provides assistance and advice to corporate clients and individuals with Canadian, U.S., and global immigration issues, including obtaining employment authorizations, temporary visas, and permanent resident status. Without further delay, Melody, welcome, and I will pass the stage over to you.
Thank you very much, Tim, and thank you to all attendees for joining us for today's webinar on Canadian Immigration 101. As many of you may already be aware, Canadian immigration is constantly changing, and especially with the most recent government, there have been many changes over the past couple of years, and it's difficult for a lot of companies and HR professionals to keep up to speed with the continuously changing requirements. Today we will be talking about a couple of key topics in Canadian immigration, and particularly how immigration impacts business and temporary foreign workers alike. We'll start with the basics, including a who's who of immigration for Canada, moving on to some preliminary considerations, including entry visas and admissibility requirements, as well as focusing a little bit on the overview of the business visitor category. When a work permit is required, what common categories may be available to you and your workers, and wrapping up with some strategies for ensuring compliance, as well as moving into other considerations outside of the scope of immigration, including tax, workplace health and safety, that Stacey will be focusing on today. Before getting into the nitty-gritty, however, it is very important to know who the key parties are that you'll be dealing with in any immigration process in Canada. Currently, there are 3 primary governmental bodies in Canada that are responsible for immigration, including Citizenship and Immigration Canada. We love our acronyms, often refer to this body as CIC. CIC is the overarching governmental body that's responsible for making all immigration laws and policy, as well as for adjudicating applications for permanent residence, citizenship, as well as entry visas at Canadian visa posts, including embassies and consulates abroad. Canada Border Services Agency, or as we like to refer to as CBSA, that's the body that's responsible for enforcing the law that CIC makes. It's the CBSA officer that you find at airports and land border crossings. They're the ones who will determine if you're eligible to enter the country. They also have the right to deport, and it's often a CBSA officer that you might hear about in the news that will be deporting illegal immigrants. For our purposes, though, it's the CBSA officers at the airports and ports of entry, land border crossings, that have some jurisdiction to adjudicate work permit applications as well. The third key body is Human Resources and Skills Development Canada, HRSDC, or as we often like to call them, Service Canada. Service Canada is responsible for testing and really protecting the labour market. And it's Service Canada that is the one that adjudicates all labour market opinion applications, which we'll discuss in a little bit more detail, but that's the most common type of work permit in Canada. So you know who the people are. What's the legislation that they rely upon? The primary piece of legislation in Canada is the Immigration and Refugee Protection Act. The most recent act was established in 2002. Before that, it hadn't been changed until 1976, and before that it was in the early 50s. So the act does not get changed a lot. It's a really big deal when it does get changed. With that, it only provides general laws. So immigration officers need to refer to the Immigration Refugee Protection Regulations to provide some added interpretation and guidance. And when those regulations, which also aren't changed frequently, when they don't provide enough guidance, they then look to the immigration manuals and operational bulletins, which are updated on a regular basis. The Foreign Worker Manual, for example, is what I like to refer to as the Bible of immigration officers. It's the one piece of documentation that officers at the borders and at consulates alike rely upon, but it also has a little bit of inconsistent information because it's updated so frequently. Now you know who the key players are. Let's take a look at some preliminary considerations. The first things to look at and really to address before you're sending or bringing a foreign worker into Canada really is, do they need an entry visa? In Canada, the entry visa is called a temporary resident visa, or a TRV, not to be confused with the TRP. The TRV is required of nationals of certain countries. Canadian government has a list of countries whose citizens will require an entry visa before they can enter Canada. If a TRV is needed, the application must always first be processed by a Canadian visa post, i.e. a consulate, embassy, or high commission in their country of residence or nationality before they can actually even get on the plane. The TRV authorizes a foreign national to enter Canada only. It does not provide them with status. So you'll see on your screen that there's a picture of what the TRV looks like. It's stamped directly into the passport, and it'll have quite a bit of information on it, including the name of the office that has issued the visa, the validity dates, as well as how many times the individual may enter Canada, if it's for single entry or multiple entry, and the category under which it was issued. As I mentioned, the visa only authorizes entry, so even though it may state worker, for example, under this category, it doesn't authorize the individual to actually work. In addition to holding on to this visa, they will also need to get a work permit. That will determine the length of time that they can remain in the country and what they can do while they're here. Another key preliminary consideration is whether or not the individual needs a medical exam before they can enter the country. A medical exam is not required by foreign nationals in all cases, but it might be depending on their current place of residence, if they've been living in a country or territory that has been designated by Canada as a high-risk country for serious medical issues. Also depending on the nature of the work that they will be conducting in Canada, as well as the duration of their assignment in Canada. So specifically, foreign nationals are required to undergo an exam if they're expected to work in healthcare, childcare, or primary secondary school education, as well as in agricultural fields. Many migrant workers will require a medical exam. They'll also need it if the foreign national is applying to come to Canada for 6 months or more and has resided in one of those medically designated countries for 6 months or more. And that list is constantly updated. You'll see that there's a link at the bottom of the screen. There's also a link in the resources section on your page as well. Because it's constantly updated, I always recommend before you plan on hiring or sending a foreign national into Canada for any duration of time to check if they need a medical exam. You would be surprised at some of the countries that do need one. Most countries in Europe do not. However, Portugal, for some reason, does. Whenever a medical exam is required, additional time should also be allotted to allow for processing, because the application must first be processed through a Canadian visa post, and that's whether the individual is a citizen that requires an entry visa or not. In addition to entry visas and medical exam considerations, it's also important to consider whether or not the individual is even eligible to enter the country, and this I refer to as admissibility. It may be awkward or tricky for some companies or HR personnel, but you really should always ask about criminal history before you're planning to hire a foreign national or to send them into Canada for any purpose, and that's even for business meetings or work. Individuals who have prior convictions, charges, or arrests may not be eligible to enter the country. One thing that is important to note as well, that depending on the nature of the charge, not just the charge that they were convicted with in their home country, but what the equivalent would be in Canada. The most common one that we see is a DUI, or drunk driving offense. In the U.S., they're often pled down to a misdemeanor or a summary offense. But in Canada, it can be charged as indictable, a much more serious charge. So anyone who has a DUI could be inadmissible to the country, and that would seriously impact their eligibility to A, enter Canada, and B, get a work permit. With that said, it's not impossible in all circumstances. Inadmissible persons can apply for a separate document known as a temporary resident permit, or the TRP, or for criminal rehabilitation. The TRP provides a short-term fix, whereas the criminal rehabilitation application provides a long-term fix. This process can often take a very long time, however. We see it often taking anywhere from an application being processed on the spot to up to 18 months for an application process through a visa post, and that's largely subject and dependent upon the nature of the charge and how many there are. Whenever a foreign national does disclose a criminal past, however, it's important to not just ask about it, but to obtain documents relating to the charge, including the court judgment, as well as any documents showing the completion of the sentence, where it happened, when it was completed, if they're still on probation, etc. And that will help both HR as well as if you're working with any legal service provider. It would help them to determine what next steps there are and what the real obstacles would be in sending this individual into Canada. After you have determined that the employee can enter the country, however, and associated visa or admissibility requirements have been met, HR must then look to what's needed to authorize their stay and authorize them to engage in the activities you want them to engage in the country. As you're aware, in operating any large business, the successful transfer of personnel across borders is paramount. In order to ensure successful business travel, it's very important to know what the immigration requirements are for that destination country. In Canada, in almost every case, whenever someone is coming into the country for business purposes, they'll almost always require a work permit. With that said, there are some exceptions. The old adage, there's an exception to every rule, there is an exception to this rule as well. Specifically, individuals may sometimes be classified as what we call business visitors, which will allow them to come in and engage in business-related activities and in some cases work-related activities without requiring a work permit. So who qualifies as a business visitor? Sounds like a great category. 4 key criteria must be met. 1, the foreign national's primary place of residence must continue to be outside of Canada. If they're going to be moving here and leasing an apartment, taking up residence here, a work permit will be needed. 2, they're entering to engage in international business activities and for the sole purpose of engaging in those activities without entering the labor market. And we'll go into that in a little bit more detail. 3, the foreign national's primary source of remuneration will be outside of Canada. Even if someone is coming in for training or other business visitor activities, if the moment they're placed on Canadian payroll, that's the moment that a work permit is triggered. And 4, the principal place of business and actual place of accrual of profits, so the company that they work for, continues to be outside of the country. Sounds easy to meet all of those criterion. With that said, I've referred to the second point again. They must be engaging in business activities because the nature of the activities is key in determining if a work permit is needed or if the individual may qualify as a business visitor. Under Canadian immigration laws, acceptable business visitor activities can include attending meetings, and that's really for discussions only. If you're working in a position where the very nature of your job requires you to attend meetings all the time, then you may also require a work permit. We often have the question of project managers and engineers who they say, well, my entire job requires me to be in meetings. The moment that you put on that engineering hat or that project manager hat, that's when the need for a work permit arises. Other acceptable activities include conducting research for a foreign-based enterprise, conducting commercial transactions on behalf of a foreign company, taking or placing orders for goods or services, again on behalf of the foreign company only, transportation operators, attending or participating in conventions, trade shows, intra-company training, as well as after-sales services. And the last 2 will go into much more detail. We'll start first talking a little bit about sales and pre-sales activities. I often have companies ask me the question of, well, our subject matter expert is with our affiliate company in the U.S. We need him to come here, though, to help prepare the bid or the tender and the proposal. We need him to really secure this contract, but it will ultimately be with our company in Canada. Clearly, they're going to be a business visitor, right? Not necessarily. Under Canada's business visitor provisions, conducting commercial transactions, including leading or engaging in discussions and negotiations, respecting the sale, purchase, etc. of goods, is a business visitor activity provided it's on behalf of the foreign company. So the ultimate contract that's being negotiated for the sale of the goods is between Canadian client and foreign company, who happens to be the individual's employer. When entry is made on behalf or in support of the Canadian company, however, a work permit will almost always be required. And the example I give here is Company ABC Canada. They've requested that subject matter expert to come in to meet with a potential client, negotiate terms of sale, draft proposals, etc. Where the project is being led by the Company ABC Canada and where the contract is known to be between Company ABC Canada and Client Canada, a work permit is required because at that point they're benefiting the Canadian company and essentially entering the labor market. Another business visitor category that many companies like to rely upon is the after-sales category. After-sales services include providing services such as preparing and servicing equipment, supervising installers of such equipment, setting up and testing commercial or industrial equipment. It also includes software that has been manufactured outside of Canada and sold to the end user in Canada. Foreign nationals may come in and do these activities without requiring a work permit, provided that the service is being performed as part of an original or extended sales agreement or contract. You may think that this will always apply to us, but not necessarily again. There are some key elements that must always be met in order to qualify as a business visitor under the after-sales service category. Specifically, when a foreign national is entering under this category, officers are instructed in their foreign worker manual to always take the foreign national aside over to secondary inspection to review their supporting documents and to confirm that they do qualify as a business visitor and don't need a work permit. In so doing, officers are supposed to look at a copy of the contract for the sale of the equipment, any supporting letters and documentation from the company as well. 3 key things that officers are specifically looking for is 1, that the contract for the sale of the equipment or software shows the direct relationship between the foreign company or the original equipment manufacturer and the Canadian end user, the company that bought it. The contract must also clearly indicate who is responsible for providing the services, and the equipment or software must also still be under warranty. Some restrictions to this particular category is anyone who's coming in to perform service work on equipment that's out of warranty or where there's no contract in existence, a work permit should be obtained. In addition, even though it provides authorization for individuals to set up, test, service the equipment, it does prohibit any hands-on building or construction work, and this is specifically for tradespersons and oftentimes union workers. Anyone who's coming in to do actual electrical wiring or pipe fitting, etc., they will not be eligible under this category, even if they do meet all other criteria. Hands-on building and construction work requires a work permit in every instance. In addition, service contracts that are negotiated with third parties after the signing of the original contract for the sale of the equipment or software are not covered by this exemption. So in the event that you want to bring in a subcontractor or a third party to perform these services, it's very important at the time of the contract writing and negotiation stage to include that in the original contract. Otherwise, they won't be eligible to enter as a business visitor, and a work permit may be required. Another very common business visitor category is training. Now in Canada, we have very strict rules when it comes to providing training. Whenever an individual is coming into Canada to provide training services, a work permit is required because training is considered to be a service, and as such, it's an entry into the labor market. There are, however, 2 notable exceptions, including after-sales training and intra-company training. From the after-sales perspective, very similar to the after-sales service provision, the foreign company must be sending someone in to provide training on equipment that they have sold to a Canadian client. Again, a copy of the contract really should be provided to the foreign national when they're entering, and the immigration officer at the border will also be looking at that documentation. So if you really don't want your foreign worker to have access to copies of the contracts, then a work permit might actually be the way to go in that instance. Another scenario where providing training does not require a work permit is in the instance of intra-company training. Specifically, a foreign company is allowed to send its employees to Canada to receive or provide training at a Canadian parent, affiliate, or subsidiary company. In these cases, the intra-company employee, they can enter Canada without needing a work permit so long as they're not actually engaging in any productive work. Oftentimes, we'll need to see a copy of the training plan. Whenever an individual is providing training at a client or a product site, that will immediately raise a red flag with officers and might pose a couple of issues. However, technically, intra-company training can be done without requiring a work permit. So you may be thinking, well, clearly, business visitor, that's the way to go, but I'm actually not sure about the activities that they're engaging in. Possibly a work permit is required, possibly not. If you're not sure, we can then look to the definition of work to help you determine when a work permit is required. As I mentioned, if in doubt, get a work permit because in almost all cases in Canada, a work permit is required. However, looking at the definition of work under Canadian immigration laws, it's defined as an activity for which wages or commissions are earned, which, as I mentioned, the moment you're on Canadian payroll, you do need a work permit, or it's an activity that competes directly with activities of citizens or permanent residents in the labor market. To determine this key point, I often advise companies to ask themselves 2 key questions. Number 1, Who has requested this worker's services? Will the Canadian company directly benefit, or is he coming in to engage in these activities for the benefit and on behalf of his foreign employer? If the Canadian company is benefiting, chances are a work permit is needed. Question 2, will the foreign national be doing work that, if he performed it in his home country, it would be part of his paid position? Or conversely, even though he might be a specialist, if there was someone equally qualified in Canada, would we hire them to do this job? If the answer to either of those is yes, then a work permit is almost certainly required. There are many different types of work permits available in Canada, each of which has different eligibility requirements, as well as application procedures and processing times. We don't have enough time today to go through every single type of work permit there is, but we can focus on a couple of common work permit categories that you'll probably come across in your day-to-day work. 4 of the most common ones that we'll talk about today are the labor market opinion-based work permit. That's the general rule for obtaining a work permit in Canada. IntraCompany transfers. Work permits issued under international agreements. For the purpose of today's presentation, we'll specifically focus on the North American Free Trade Agreement, as well as work permits for dependents. If you have someone who you're hiring either on a long-term delegation or as a local hire, are their dependents eligible for work permits? Can their spouses obtain a work permit, or even their children? We'll take a look at that as well. Starting first, though, with the general rule for obtaining a work permit in Canada. The labor market opinion-based work permit, it involves a 2-step process, whereby first, an application is made by the company for a labor market opinion, or an LMO, from Service Canada. Second, once the LMO has been approved and issued, then the foreign national may apply for his or her work permit. Depending on where they're a citizen of, or if they need a medical exam, that application is either made by the foreign worker to a visa post abroad, or it can be made at sometimes at the port of entry when they arrive in the country. We'll look first to the labor market opinion application that the company makes, and specifically key things that Service Canada is looking for. In order to obtain a positive LMO in Canada, the employer must meet certain requirements according to the position offered. Example of these requirements include a minimum salary offered. Specifically, companies don't need to think only of minimum wages per Employment Standards Act, which Stacey will address later, but also prevailing wages. For example, what is the average wage that Canadians are earning in that position and in the region? Service Canada also looks to the maximum number of hours required of the position, as well as to the company's efforts to hire a Canadian citizen or permanent resident first. That's their way of testing the labor market, and that's typically shown through advertising. Service Canada does have some minimum mandatory advertising requirements to demonstrate that the company has made the necessary recruitment efforts to hire a Canadian before a foreign national. These advertising requirements vary depending on the nature of the position. For managers, executives, and some professional occupations, which they're classified under Canada's National Occupation Classification Skill Levels O or A, companies need to conduct similar recruitment efforts that are consistent with the practice within the occupation and industry, or advertise on Service Canada's National Job Bank for at least 14 calendar days during the 3 months prior to the application. I always recommend to clients post for at least 17 days just to be on the safe side. And when you have the option, be very careful when you're creating the advertisement, especially if using the job bank. Service Canada's job bank can be a little bit tricky. For anyone who has not used it before, it does require a series of drop-down menus to be filled out rather than allowing the company to truly customize the advertisement. If you're looking to hire a foreign national in a skilled level position, for example, as a technician, then there are additional advertising requirements. Not only do you need to advertise on the Service Canada Job Bank, that is a requirement, but you also have to advertise in at least a second location that is consistent with the company's practice and for the industry. In addition, when you're advertising for a skilled level position, the advertisement must include key information, including the company's name, the business address, the location where the work is expected to take place, a wage range, while noting that the range of salary must include at least the prevailing wage, and other key references to any benefits or other bonus packages that are being offered as part of the position. Once a Service Canada officer has assessed and adjudicated the application, they will then issue the labour market opinion. With that said, it does take quite a bit of time depending on the location where the application has been filed. LMO applications are filed at the Service Canada officer that is responsible for the province, and as such, they really are province-specific. It's not possible to get one labour market opinion to allow a foreign national to work across the country. Processing times do vary from province to province. In Ontario, the standard processing times that they are currently reporting is about 30 business days. We're seeing it close to about the 4 to 6 week mark. In Alberta, it's a little bit longer. We see about the 8-week mark. Manitoba is reporting 3-month processing times for standard LMO applications. Once the LMO has been approved, then there's the work permit part of the application process by the foreign worker. If they're visa exempt and do not need a medical exam, they can apply directly at the port of entry. If they're going to a visa post abroad, however, then processing times vary depending on which office it's processing at, and that can really range from 4 to 6 weeks, which we're seeing at consulates in the U.S., to 7 to 9 months, which we often see at consulates in the Middle East. In terms of duration, how long the work permit will then be issued for after you've obtained a labour market opinion, the maximum duration is 3 years. However, since the economic downturn a few years ago, we have been seeing many offices are only issuing it in 1 to 2 year increments only. Something also that's very important to note, the Canadian government recently changed our regulations impacting foreign workers, and now it's a requirement that anyone who's working in a skilled or low-skilled occupation, so technicians or any low-skilled workers such as tree planters, etc., they will be limited to holding a work permit for a total cumulative period of 4 years. After they've held this type of work permit for 4 years, they will not be eligible to apply for another work permit until they've been outside of Canada for 4 years. So it's a 4 year in, 4 year out rule. With that said, there are many exceptions to that 4 year cap rule, and as I said, one of them being the level of the position. Managers are exempt from it, as well as certain type of work permits. Now, as you can see from the processing times, the rules that are associated with it and caps, the labour market opinion can be quite onerous. To address these really lengthy processing times in particular, Service Canada, together with CIC, introduced a new initiative called the Accelerated Labour Market Opinion Initiative, which allows Service Canada occupations to be, or Service Canada applications to be processed within 10 business days. Sounds great. There are, however, many requirements to be eligible for the ALMO initiative. One is companies must have been issued at least one positive LMO in the last 2 years. They must have a clean record of compliance. They cannot be subject to any immigration investigation or complaint, no unresolved violations, and they must agree to a series of attestations. With the introduction of these attestations, the onus is really being placed on the employer to ensure that they are fully compliant and that any substantial changes to employment, including changes in salary, either an increase or a decrease in salary, location of work, hours of work, etc., are reported to Service Canada and, if need be, a new labour market opinion obtained before that change takes effect. Another thing to note with the ALMO initiative is all employers must agree before they submit the application to participate in a compliance review, aka audit, during which Service Canada would then, after the fact, review all employment terms of all of your foreign workers. Right now we're finding only about 1 in 5 applications are subject to an audit. However, it's something that every employer should be prepared for. With all of these requirements associated with the LMO, though, we really do like to find LMO exempt work permit categories. The most common one that we see is the IntraCompany Transfer category, where special consideration is given to companies who are looking to transfer specialized knowledge personnel or senior managers to their Canadian parent, branch, affiliate, or subsidiary. Intracompany transfers do not need the LMO beforehand, so it's only a one-stage application process. To qualify, it is available to citizens of all countries. Foreign nationals must be working in either a senior managerial or executive occupation or in a specialized knowledge occupation. The foreign national must have been employed by the related company outside of Canada for at least 1 year, and they must currently still be employed by that company. And both the Canadian and the foreign entities must be permanent and continuing establishments. Intracompany transfer work permits are typically granted for an initial period of 3 years. Unless the individual is being parachuted into a client site, then typically 1-year work permits. They can also be renewable for a total period of 5 years for specialized knowledge workers or 7 years for executives and senior managers. Huge benefit to this type of application is the processing times. If the individual is visa exempt, then they can apply at a port of entry. Again, if they need a TRV, they still have to go through a visa post. Another LMO exempt work permit category is under international agreements. There are quite a few agreements that Canada has entered into, including the North American Free Trade Agreement, the Canada-Peru Free Trade Agreement, Canada-Chile Free Trade Agreement, etc. Today, as I mentioned, we are going to focus on the NAFTA, which, because I understand we have many U.S.-based companies, the cross-border business really reflects the NAFTA. The NAFTA does include specific provisions that allow American and Mexican citizens to obtain an LMO exempt work permit. Unfortunately, it's only available to citizens. Green card holders do not qualify. It does have a list of professions on the NAFTA that are acceptable for this type of work permit. There's 60 occupations in particular. The most common that we do see, however, are engineers, computer systems analysts, technicians, and management consultants. Key criteria to qualify for this type of work permit. Really, it's for skilled professionals who are entering Canada to provide prearranged professional services, either on behalf of their U.S. or Mexican employer to a Canadian company, or indirect employment with the Canadian entity. As mentioned, the skilled professional must be entering to engage in a profession, to work in a profession that's listed under the NAFTA. They also must meet minimum education requirements. For almost every single profession, that does mean a bachelor's degree in the related field. Typically, this type of work permit is granted for 1 to 3 years. It is often subject to the nature of the work. If they're coming in to provide consulting services, and the contract for consulting services is for 1 year, then typically the work permit would only be issued for 1 year, but up to a maximum of 3 years for all other professions. Processing times, much like the intercompany, for U.S. nationals, they can apply directly at the port of entry, so it's on-the-spot processing. Mexican citizens do need a TRV, unfortunately. In Mexico, it's currently taking about 6 weeks for that type of visa and work permit application to be processed. When you have the foreign national that you want in Canada, they've obtained their work permit, what about their family? Canadian immigration laws do allow for some accompanying dependents, including both spouses and children, to obtain what we call open work permits in Canada. An open work permit is a work permit that has no restriction to employer, employment location, or occupation. So the spouse, common law partner, or child can work in any position. For spouses and common law partners in particular, the key requirements are that the principal worker, so your employee, holds a study permit or employer-specific work permit authorizing work for at least 6 months or more in a skilled professional or managerial position, and that they're going to be actually residing in the country during that period of time. Children are also eligible for open work permits in some instances. Specifically, children who are of working age and intending to work in Ontario, Alberta, or British Columbia can obtain an open work permit. These are currently pilot projects that are specific to these provinces only. Ontario and Alberta have projects that are currently valid until July 2013. BC's is valid until February 2014. They just extended it by 1 additional year. With respect to the way to apply for a work permit, we've already discussed that these exempt nationals can often apply for their work permit at the port of entry. Anyone who needs a TRV or needs a medical exam, they have to go through a visa post. If they're already in Canada, then they may be able to extend their permit by submitting an application to the Case Processing Centre in Vegreville, Alberta. And for anyone who's not fully familiar with what the work permit document looks like, you can take a look at your screen right now. It's a lovely, you can't really tell, but it is a lovely manly pink color. It does contain a lot of information and specifically conditions that I recommend every company obtain a copy of the permit and review before you start employing the foreign national. A couple of key things to look at on the left-hand side really are the conditions, the employer that they're authorized to work for, the occupation in which they're authorized to work, employment location, and any other conditions. Now, I know we are running a little bit short on time, so I won't go into too much detail with respect to the penalties and ramifications, other than saying that compliance. Companies and employees alike can be subject to very serious penalties if you're found either to be hiring a foreign worker without a work permit or hiring them in a position or paying them a wage that doesn't reflect what they've been authorized to do. Particular impacts on employees can include fines, bars from applying for a future work permit if they're entering Canada saying that they're coming in for meetings, but then it's discovered that they're not. Bar from entering the country. A charge of misrepresentation can be an automatic bar of 2 years, potentially arrest and deportation. For the company, there's a bar from hiring foreign workers. If a company is found to be non-compliant under our new regulations, you can be banned from hiring foreign workers for up to 2 years, and your name would be publicly listed on a blacklist with Citizenship and Immigration Canada. You could also be subject to some fines, potential imprisonment, as well as litigation. If an employee is banned from entering the country for any purpose because they followed the direction of the manager, they can then come back and sue the company. So what do you need to do to ensure compliance? 5 key things that I would always recommend. Number 1, first and foremost, plan ahead, because you never know what surprises you might get. You might be sending someone into Canada, they go to the border, they don't have documentation, they say that they were charged with a criminal offense. Planning ahead allows you to plan for all instances and have no surprises. It also enables you to then in turn plan for your projects accordingly. Number 2, confirm if a visa is required. 3, ensuring that every foreign national is entering Canada with proper and thorough documentation. 4, tracking work permit history. You don't want to hire someone who only has 2 months left on their work permit and they're subject to a cap. And 5, monitoring terms and conditions of their authorized work. This is important not only for immigration purposes, but is also to be kept in mind for all other purposes, including tax, health and safety requirements, and other considerations, which Stacey will now be able to tell you a little bit more about. On to you, Stacey.
Great. Thanks, Melody. That was some great information. And now that we know which permit we're bringing our U.S. people into Canada on, we need to look at what you as an employer are obligated to do while they're here. So employing a foreign worker depends greatly on their individual circumstances. I'm not a lawyer and I'm definitely not an accountant, but I wanted to bring to your attention a few considerations before you decide to employ in Canada. If you already have an entity in Canada set up and going, the decision to send your U.S. employee here becomes easier. Your Canadian entity already is registered with Revenue Canada. They probably have payroll in place. You hopefully have an HR person trained in Canadian legislation handling your employment standards and human rights requirements. And your workers' compensation is all set up and ready to go. So as long as the work permits come through, it's a simple process to employ them. If you don't have an existing Canadian entity, you may employ them yourself. There are a lot of considerations on that choice that I want to take you through, depending on what length of time you're sending your U.S. worker into Canada for. So in Canada, the governing body for everything income and tax related is the Canada Revenue Agency. And the CRA, as we call it, is equivalent to the IRS in the U.S. So when you send an employee to Canada, the CRA will be looking at the employee's status and their earnings while they're here. As soon as the employee starts earning income in Canada, you as the employer must report that income to the CRA. This includes remitting the employee and the employer taxes. And the employee's income earned in Canada will be taxed like any other Canadian. It'll be taxed for income tax, Canada Pension Plan, employment insurance, and other taxes depending on the province, like Ontario's health tax or a surtax, and of course taxable benefits. So this is where timing comes into play. If the employee is in Canada longer than 183 days or roughly 6 months and treats Canada as their residence, they're looking, and by that I mean they're looking either to be permanent residents, they've bought a house here, they're planning on being here for some time. Canada will treat them like any resident and tax them on their worldwide earnings for the year. So that includes any earnings they may have had from the U.S. earlier in the year. Alternatively, if they can show that they are non-resident, so they're truly only here for a short period of time, they will not only be taxed by the CRA on the income they actually earned they'll only be taxed, by the income that they earned while they're in Canada by the CRA, not their worldwide income. So you, as the employer, will have to remit the taxes to Revenue Canada in either case, whether they're a resident or a non-resident, and issue the employee's T4, which is very similar to the U.S.'s W-2 form. And finally, if you know for sure that your employee is only temporarily in Canada, there are arrangements through the Canada-U.S. tax treaty that you can take advantage of. You can obtain a waiver from the IRS to present to the CRA to show that the worker is being taxed and paid out of the U.S. There's a lot of paperwork involved to completing the waiver, and they're generally only acceptable on a 6-month period. So if you do know that your worker will be in Canada longer than 6 months, I would recommend that they be set up on Canadian payroll. If you do have a lot of questions regarding Canadian returns, you can call us and we can refer you or your employee to a cross-border accountant. Great. You should also be looking at the health and safety of that U.S. worker that you're sending to Canada. It's your responsibility to ensure that your workers are properly trained and supplied with the equipment that they will require to be safe on the job. So workers' compensation in Canada is provincially governed. In Ontario, for example, it's through the Workplace Safety and Insurance Board, or WSIB, or in Quebec through the CSST. Each province decides who and what they will cover. So if, for example, you're sending your workers to Ontario or British Columbia, they have to be covered by those provinces' workers' comp plans within 10 days of working. However, if you're sending your employees to Alberta or Quebec, those provinces will not cover a U.S. employee from a U.S. company, and you're on the hook for your own insurance coverage. Many companies that you'll probably be doing business with in Canada will request a certificate of proof of insurance that you're covered either through the workers' compensation of that province, or if you don't have that coverage, you'd have to provide that certificate yourself. And if you do have your own coverage for the employee, you might want to present that coverage extension letter as evidence to the workers' compensation board in the province that the employee is working in so that they can waiver your company from having to pay for that coverage. As with any legislation, like Melody mentioned, there's exemptions for everything. And for each province as well, based on the province's employer classification manual, you'll want to look up what may or may not apply to the employees that you're sending here, depending on the industry and also the profession that they're in. So beyond, beyond taxes and workers' compensation, yes, there's more you have to consider. You have to look at the compliance obligations with employment standards and human rights. Any worker entering the labour market in Canada is covered by employment standards in the province that they're performing the work from the day that they start. So there's a few important employment standards I feel you should pay special attention to, even if your employees are only here on a short term. So firstly, hours of work. I've had a lot of clients say that they want their employees working 60-hour work weeks. Each province has its own rules around hours of work. In Ontario, for instance, they only allow for 48-hour weeks maximum. So to go above and beyond that, it requires a written agreement and consent from both the employee and from the Director of Employment Standards. And that process of approval can take sometimes up to 6 weeks. Secondly, if you require employees to work over their daily or weekly maximum hours, you have to pay them overtime for those. And the typical overtime rate is about 1.5 times the worker's hourly rate. Thirdly, you should also account for public holidays. So if the employee, if they do work them, are typically paid at 2 times the employee's daily wages if they agree to work them. And fourthly, you should consider vacation pay. A lot of U.S. companies forget that, but generally speaking, vacation pay is about 4% of all gross earnings for any worker across Canada per year. And finally, you should be informed about termination notice payments. Although those are pretty small for employees in Canada only for a short time, for example, an employee terminated after 3 months working here but less than a year would be required to be paid out 1 week or work 1 week of wages as notice of termination. And employment standards generally requires 1 week of wages for every year worked up to 8 weeks as termination notice to the employee. So it does seem silly to take all of these employment standards into consideration for a worker who is only here for 6 months, but speaking with several attorney partners of ours, they often see foreign workers successfully suing for their rights under the Act. So if you had an employee making $100,000 and you didn't give them any paid time off, by the year end you would owe them $4,000. So it's better to deal with employment standards ahead of time rather than risk an issue that could potentially affect your immigration record. So of course, like with all legislation, you have to check for exemptions. Under most employment standards legislation, there are certain professions in which all or parts of the Act don't apply to them. For example, professional engineers, they're generally not covered for any employment standards in regards to hours of work or overtime. However, their terms and conditions should be written into their Canadian offer letters. And on that note, you should have new offer letters created for any of your employees who are coming to Canada just to help address their employment terms and conditions. Human rights legislation also applies per province, and violating the code could get you into a heavy lawsuit here. The average award for successful complaints in 2012 was over $10,000. So just be aware and not to discriminate your employees based on any of our protected grounds. Including drug testing, that's been one of the big ones that a lot of clients have asked me about, and that's typically a no-no here in Canada, but that's probably a topic for another day. So finally, I do want to talk a little bit about some alternatives to the do-it-yourself route that I've been discussing. Firstly, before you go through the process of registering with all the different governing bodies in Canada, worrying about legislation or taxing or independent contractor services or workers' compensation, you can contact a third-party employment firm, just like HR Options, to work with you. We would employ the U.S. worker for you and handle the permit process and all the Canadian aspects of employment while your employee's here. We would be the employer of record for your employee, and as such, we would work with you along with Bomza Law Group Immigration to bring the employee to Canada through a tripartite permit application process. So we would handle the employment and provide you with an invoice for weekly services. And also a final option that we usually recommend would be, if possible, hire Canadian to do the job wherever possible. We could also, we do employ Canadians for U.S. corporations and be happy to walk you through what something like that might look like, just to save yourself a lot of headaches in understanding Canadian immigration and employment systems in Canada. So I do want to thank you very much for listening today, and now I'm going to turn things back over to Tim to start the question and answer with Melody and myself. Tim?
Thank you so much, Melody and Stacey, for providing with some great information. We've had several questions come in, so let's get right at them. I want to remind everybody, if you could, please, we would appreciate it if you would fill out the webinar evaluation, which is the red widget at the bottom. If we do not get to your questions, Melody and Stacy will answer those individually or collaboratively. We have all of your contact information via your registration, so we'll do that. So let's jump right in. Let's see. First question, I'm going to throw it out to Melody. Does residency for Canadian tax purposes affect residency for Canadian immigration status? Can a person be a non-resident for tax purposes but still be a Canadian permanent resident for immigration brackets visa purposes?
That is an excellent question. When we're talking about permanent residence in Canada, and it's very important, even though immigration and tax really do interconnect, they're also very separate from a legal perspective. Residency requirements as a permanent resident in Canada, it's focused on the days that you're actually physically present in Canada. Now, I understand for tax purposes, and perhaps Stacy can speak a little bit more about this or refer you to a professional tax accountant, that you do have a 183-day requirement, I believe. For a Canadian permanent resident to maintain your permanent resident status, you have to be physically present in the country for at least 2 years out of every 5-year period. So in a 1-year period, you may not be in Canada at all, but then 2 years after, you're here for the full 2 years, or you're here for 700 days, and then after that. So really, for maintaining permanent residence from an immigration perspective, they look at a 5-year period rather than a 1-year period, which I understand is a tax perspective.
Yeah, that's right. Yeah, Melody, that's exactly right. The tax purposes goes by the year, and again, the 183 days. And also the intention of being a permanent resident affects your residency status in terms of taxation. So whether or not Canada feels that you will be taxed Canadian-wise for your worldwide income, or whether you're just going to be taxed on your earnings while you're in Canada, or whichever way you're going, depending on how long you're actually in Canada and your intention on staying in Canada.
Okay, wonderful. I'm just looking through the questions just to make sure that we're asking ones that haven't been answered already, but let me just see. Can you speak to how immigration rules affect new immigrants when it comes to buying or renting a home in Ontario specifically? Or is that something that...
Yeah, I can't speak too much about requirements for buying or renting a home. One thing that I can talk about from the immigration perspective is that many banks do require you to have valid status in Canada in order to be approved for a mortgage. Same thing goes for if you're applying for a credit card even. They will want to see that you have a valid work permit or permanent residence status as shown by your permanent resident card or record of landing document. In terms of there are any other specific requirements on the banking or the home purchasing side, I can't speak to that, unfortunately.
Okay. That's great. Thank you. Here's another question. For a business visitor, if the main 4 criteria are met, is a consultant or practitioner eligible for this visa? The duties for the practitioner are teaching the business company's process to the Canadian company.
Okay, the first question that I would revert back would be to look at what the relationship is between the company that the consultant works for and the client or the company in Canada, or if it's an independent contractor consultant coming in to provide teaching or training services. Typically, the provision of teaching or training and even consulting services is considered to be work in Canada and does require a work permit. So even you would think that the 4 criteria are met, you have to look back to what the business activities are. Training and consulting do require a work permit unless one of the exceptions under the training provision apply. For example, you're employed by a company in the U.S. and you're providing training or teaching employees of your affiliate company in Canada.
Wonderful. Fantastic. Here's a question that I think it may require a collaborative answer between Stacey and Melody. We have employees from our Europe head office visiting for 6 months to work in Canada. Can we pay them through AP, accounts payable, I guess, and not deduct tax as it is temporary work permit?
From an immigration perspective, I can confirm that the source of payment has no impact on eligibility for a work permit. It may impact what type of work permit that they may obtain, but they can be placed on an international payroll. They can stay on the foreign company's payroll. From an immigration perspective, it doesn't have an impact. Stacey, I don't know if you can speak to a tax perspective.
Right. From a tax perspective, it will depend if there's any treaties or agreements with wherever you're from Europe. I don't know all the details, but you'd have to look to that first on whether or not you can leave them on your own payroll or leave them with your own payment system, whatever you're doing in Europe, versus what you can do here. If there's no treaty in existence, then as soon as they are here, you are going to have to file taxes and remit taxes to the CRA.
Great. Okay, let's see. We have time for one more we can squeeze in. And I encourage everybody to fill out the evaluation on the webinar, as I mentioned before. We'll get to the last question. We've applied for a work-sharing agreement through Service Canada. As well, we have employees on a work permit. How would the work-share agreement affect those employees? Could the work permit employee participate in the work-share agreement?
It would really depend on the nature of the work share agreement. Individuals, or if you have employees who are currently on work permits, again, take a look at what type of work permits they hold. If they hold an open work permit that authorizes them to work for any company in any position, there really are no restrictions in that regard from an immigration perspective. It may, however, impact your eligibility to obtain labor market opinion-based work permits for future foreign workers. There is a specific question on the labor market opinion application form that does ask if you're party to a work-sharing program. Work-sharing programs really are designed to help encourage and foster employment of Canadians in most instances, so Service Canada will want to see that you're hiring Canadians first and foremost before hiring foreign workers. However, for those who are currently on a work permit, they're not going to lose their work permit status just by that agreement.
Wonderful. Fantastic. We are out of time for today. So I'd like to, first of all, the last slide that you're seeing here, I sincerely apologize. I forgot to put Melody and Stacey's email addresses up there or websites. Melody, if you'd like to mention to the listeners what your email address is, they can, if they want to contact you.
Absolutely. You can reach me at mhughess, that's mhughes, at bomzalawgroup.com, all one word, BOMZALAWGROUP.com. And our website is the same. It's www.bomzalawgroup.com, all one word.
Wonderful. And Stacey, yours is sglass, S-G-L-A-S-S, at hroptions.com. And, of course, our website is hroptions.com or .ca. Wanted to thank Melody and Stacey today for preparing and sharing this information with us. It was fantastic. For all those people that we didn't get to as far as questions, we will follow up with you. Wanted to thank everyone for joining us today and look forward to seeing you at other future online webinars, and hope you have a wonderful day.
Thank you.